Yes, I think.
May please, Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship. I pray if this matter can come up after 2 weeks. I've already informed the petitioner, Your Lordship.
Lordship, no objections, Your Lordship. If 3 weeks time may be given, Your Lordship, because my senior will also be out of station.
On pre-made by the parties, let's this matter after 3 weeks.
Highly obliged, Your Lordship.
Your Lordship, a similar prayer of item number 18, Your Lordship. Mr. K.P. Bhattacharjee, he is having hearing before the Chief, Your Lordship.
Lordship, and for the petitioner, Lordship.
If this matter can come up after 2 weeks, Your Lordship.
After vacation, Lordship.
After vacation. On pre-made by the state respondent, not objected to by petitioner. Matter is adjourned. Let's see after 3 weeks.
2 weeks, Lordship. Deeply obliged, Lordship.
Please, Lordship, I beg to mention item number 22, Lordship. As a pray for the matter may come up after 2 weeks, Lordship, for hearing.
On pre-made by the petitioner, let's this matter after 3 weeks.
May I please, Your Lordship? I beg to mention item number 17, Your Lordship.
Item?
Item number 17, Your Lordship. I pray for 2 weeks' time, Your Lordship. Pray for 2 weeks' time, Your Lordship.
Before petitioner.
Yes, Your Lordship.
And for the state,
On pre-made by the petitioner, let's this matter after 3 weeks.
Highly obliged, Lordship.
From supplementary cost list, item number 1.
May I please, Your Lordship?
Which case is this?
Bail and 2. Lordship, this is a bail application under 438, Lordship. The FIR was filed.
This is C with number 2.
Number 2, yeah. 1 and 2 is same. Same case, out of the same case. Lordship, the FIR was filed on 21/10/2023 before the Rajawala police station, my lord, alleging that the complainant's son was attacked by 5 persons and they ran away from the spot and he sustained bodily injury, Lordship. Thereafter, police acting upon the FIR has registered a case being Rajawala PS case number 14/10/2023 under section 324, 307 and 34 IPC, and accordingly initiated the criminal investigation, and the petitioner herein is apprehending his arrest. Apprehending his arrest, the petitioner has filed first anticipatory bail application before District and Session Judge Tura. The same was rejected on 2011-2023.
On what ground?
On the ground that the victim is not recovered from the injury, and thereafter the second bail application was filed before this the learned District and Session.
When was the FIR filed?
FIR was filed on, Lordship, 21/10/2023.
Case number 11.
Annex is page 11, annexure 1.
21/10/2023.
Yes, my lord. Thereafter,
Now we are in March.
24.
How many months have gone?
It's been
November, December, January, February.
almost 5 months. Almost 5 months.
5 months we have not been arrested. So where's
My
the
lord,
apprehension?
my lord, I'm seeking. Still, my lord, there is a chance of as police is now and then asking about the accused, and the accused person herein in this matter, Your Lordship, is working in Bhaitbari CHC as a casual worker under Health Department. So the another accused had enlarged on bail by this Honorable Lordship as grant bail, Lordship. So, the Shirazul Ali, bail application number 1 of 2024. So on this,
Annex that order there?
yes, my lord, we have annex, my lord. Annexure 5, my lord. Annexure 5, page
Yes,
17,
Mr.
my lord.
My lord,
On parity.
My lord, if my lord will see the content in the FIR, my lord, the offence seems to be very serious. He has stabbed with knife, and moreover, they are
Whatever the
approaching
case may be, see, investigation is going on. They will eventually come to a finding whether the accused person is guilty or not, or has committed the offence or not. The trial will take its own course.
my lord.
And the petitioner here is a casual worker.
They are very young. Both the parties are very young, Lordship.
Why unnecessarily burdened? This court will allow on the basis of basis of parity.
My
And my lord, as far as the other bail applications, my lord, other bail which was granted, it was as per the order which is enclosed, my lord. He was granted because of his exam, because he was a student, my lord, of class 12. And this is not the case as far as this instant case is concerned. Slightly different footing, my lord.
My lord, both the parties are at the age of 20, 21, 19, the student only. The second bail application, item 2, he is also the student. Here he is 20 years of age, Lordship. There is no criminal antecedent, Lordship.
My lord, since it's mentioned item number 2 also, I'm appearing in item number 2.
We'll look into it.
Ready to cooperate with the my lord investigation. Some protection.
Is there any history of enmity between the
No,
parties,
my
the
lord. Actually,
victim and the-
what was happened? The victim and the accused here, they are very young age. They, because of some personal disputes, like with regard to some girls, they are started fighting each other. As per my instruction, Lordship. So they are fighting each other, Lordship.
My lord, stabbing with a knife and such a serious 307, my lord.
Anybody can do anything for a girl.
My lord, this is the incident happened
Young
because
people,
of
see, they are
the
young. This is no criminal antecedent.
my lord.
Heard Mr. S.K. Hassan, Learned Counsel for Petitioner. Also heard Mr. Ensign Khan, Learned GA, appearing for the state respondent. An FIR dated 21/10/2023 was filed, was lodged before the officer in charge, Rajabala PS, West Garo Hills, wherein the complainant, the informant therein, had alleged that his son, aged about 19 years, while on his way to his relative's residence at Kandergaon, AMPT, capital itu, AMPT Road, five persons attacked him with criminal intention and stabbed him with a knife, causing grievous injuries on his person. The assailants then fled away from the spot. On receipt of such FIR, the police had registered a case being Rajabala PS case number 14, number 10/23 under section 324/307/34 IPC, and investigation was launched. the petitioner herein later came to know that he was implicated in the said case, and for which the police had come looking for him. And for which the police had come looking for him. Accordingly, being apprehensive of an imminent arrest, he had firstly approached the Sessions Court at West Garo Hills, Atura, West Garo Hills district, praying for grant of pre-arrest bail, which was rejected. On his second attempt, this is the second bail application.
My lord, the second bail application was rejected in district and sessions Tura, lordship. This is the first bail application in High Court, lordship.
It's then twice he had.
Twice in lower court, lordship.
So twice one. This is the third application for grant of pre-arrest bail filed before this court. On a query made by this court, the learned counsel for the petitioner has submitted that the earlier bail application was rejected by the learned court on the ground that the alleged victim was still under treatment and perhaps could not give his statement before the police. It is also the assumption of the learned counsel for the petitioner that the petitioner herein is a young person who is working as a working as what?
Casual worker at Hydebury CHC.
Casual worker on temporary basis.
On temporary basis.
At the office of the district medical and health officer.
No, district and medical health officer has appointed him. He work in the Hydebury CHC, my lord.
Working at Hydebury
CHC.
Community Health Center, CHC, West Garo Hills. He has no criminal antecedent, and if arrested, his reputation and future will be jeopardized. It is therefore prayed that this petition will be allowed, and in the event of his arrest, if enlarged on bail, he will abide by any condition to be imposed by this court. Mr. Ensign Leonard G has opposed the application, this petition, on the ground that the offence involved is serious, and prima facie it appears that the petitioner is involved in such incident. This court, while noting the concern of the parties as far as the respective case is concerned, would observe that the case in question is under investigation. Charge has not been filed.
I'm not aware. I have just received the file, my lord.
And nothing on record is available to show that charge sheet has been filed in the case. Be that as it may, it is reiterated that as far as bail application is concerned, notwithstanding the particular facts and circumstances of the case, it is always the endeavor of the court to ensure the endeavor of the court or the system for that matter to ensure that the accused shall not abscond and that he or she shall cooperate with the investigation and make himself or herself available as and when required. To this extent, if the petitioner can bind himself under such condition, this court at this juncture would allow the prayer made. Consequently, the prayer of the petition is hereby allowed. In the event of his arrest, he shall be enlarged on bail on the following condition: that he shall not abscond or tamper with the witnesses and evidence and witnesses, that he shall not leave the jurisdiction of the state of Meghalaya without due prior permission from the IO or the court concerned, that he shall personally bind himself on a personal bond, on a bond of 30,000 with one surety of Lycom to the satisfaction of the IO concern. What else?
Enough, my lord.
Anything else?
Obliged, my lord.
Accordingly, this petition is hereby disposed of.
Item 2 also similar in this, out of the same case, my lord. Another accused, my lord.
Lordship, I'm appearing on item 2.
Irshad
I have some submissions to make. Hold on.
In item 2,
Lordship,
who is the petitioner in item 2?
My lord, item 2, Irshad Alam, my lord.
What is his occupation? What is his age?
He is a student of madrasa. He's doing Maulana course.
how old is he?
20 years. 20 years old, lordship.
Maulana course.
Yes, lordship.
And he still goes around fighting.
Lordship, that's what I submit before. There is between the both the parties are in the same age. They all are students, except the petitioner Nur Alam. He's also 20 years age. He got job on casual basis. All are student here in my lord. Because of some girls, they are fighting each other, and these things happen, lordship. So,
Yes, sir.
Lordship, may it please this honorable court. Lordship, in the first instance, Lordship, looking at the petition and also the grounds made herein, the only ground for filing this present application is on the basis of parity, Lordship. My lord, when bail was granted, anticipatory bail was granted on the last occasion, it was because that applicant was appearing for the board exams. That is the reason for grant of such bail, anticipatory bail, Lordship. Lordship, over here, there's no parity. They cannot claim parity over here, my lord. That's my first ground. Second ground, Lordship, the bail application rejected by the trial court was dated 4th of January 2024. After 2 months and a half, they come again with application before this honorable court, Lordship. Lordship, there's no imminent or threat to arrest, Lordship. And as such, they're here after 2 months and a half. So where's the apprehension, my lord? Had there been a real apprehension immediately after it was rejected by the trial court, they should have approached this honorable court, my lord. There was none. So, Lordship, on these two grounds, and also take into consideration that 307 is involved, I pray that anticipatory bail may not be granted at this stage.
Where's the averment made as regard the question of parity?
Lordship, it is at paragraph 7, my lord.
yes, lordship. Right. Yes, at para 7.
At page 5, Lordship.
Page 5.
The last statement, Lordship.
Yes, it is logical that if you come before court seeking benefit
Yes,
on the ground of parity, your case should stand on the same footing
Yes.
as the other case.
Other case, yes.
If I recall correctly,
Yes, Lordship.
the case was, bail was granted because the petitioner therein was appearing in some exams or something.
Yes, correct, Lordship.
Board exams.
Board
Lordship.
exam, 12th exam,
Whereas you are not appearing in any exam. You may be a student,
my lord.
you're not appearing in any exam.
My lord,
so that could not be.
my lord,
you
my lord is
cannot-
correct,
You cannot
my
say
lord.
that parity. You
since
cannot
the-
claim parity.
My lord, if I am not claiming parity also, my lord, since the other two accused also got bail on this the same connected matters, looking at the age of the, is a student, Lordship. Looking at the age, is 20 years age, and no criminal antecedent, no previous criminal antecedent, Lordship.
They're making
So
a
at
different
this stage,
submission from the pleadings, my lord.
No, I made
Because-
that submission at the no criminal antecedent, prior criminal antecedent, Lordship. Lordship, may I read, Lordship?
Please.
Yes. Para 10. The petitioner undertakes that he would make himself available as and when required by the police for the purpose of fair investigation, and shall cooperate in all aspects for the fair investigation of the case, and he will not directly or indirectly do anything which is constitute to be prejudicial for fair investigation, inquiry and investigation, and he would not do anything for tampering or hampering for of evidence, and he would be further obliged to follow to all terms and conditions as may be imposed by this honorable court and court while grant the pre-arrest bail to the petitioner, and further undertakes to abide by the terms and conditions imposed by this honorable court. The para 11, my lord. The petitioner is a student of madrasa studying Maulana course, and he hails from a humble and respectable family background, and in the event of any arrest, his future academic career will be finished, and he shall be maligned and disgraced in the eye of society, and his life and liberty will be jeopardized, Lordship. Para 12. The petitioner is a law-abiding citizen and having no previous criminal antecedents whatsoever during the course of his life, and he would not abscond if he is enlarged on pre-arrest bail by this honorable court. Lordship, looking at the age, Lordship, they are a student. That is what my first submission before when I moved, Lordship. So I humbly pray, Lordship, kindly grant this on the same line, Lordship, kindly. Since the Nur Alam also, the other accused also.
You're not aware whether charging was filed or not?
Lordship, the matter has just been endorsed, Lordship. And with regard to antecedents, my lord, I will not be aware right now unless I confirm with the IO as there are any other cases or not. But Lordship, the main ground for them coming before this honorable court is relying on this honorable court's order and judgment, claiming parity. And this is our the strongest objection that we have, Lordship, that there's no parity. And secondly, where was the immediate threat of arrest, Lordship? Coming after 2 months and a half and seeking anticipatory bail before this honorable court, Lordship.
Heard Mr. Lesson letter counsel for the petitioner, who has submitted that this petition was filed. This petition has been filed. We pray for grant of pre-arrest bail in connection with Rajawala PS case number 14-10-2023 under section 324-307-34 IPC, wherein on an FIR lodged before the Rajawala PS Fulkitomo by the informant, who is the father of where's the FIR?
Our Lordship, at page 10, Lordship.
Who is the father of one Shamim Imran
Imran
Sarkar,
Sarkar.
alleging that his said son was attacked by 5 persons, one of whom is the petitioner herein, and as a result of which he was stabbed by a knife and thereby received grievous injuries on his body, on his person. To which the police, on verification, has registered said Rajapala PS case number 1410 of 2023. An investigation is launched. The Learned Counsel has submitted that the petitioner hearing, being apprehensive of an imminent arrest, has approached the trial court, has approached the court of the sessions judge, West Garwils Tura West Garwils. What is, how many applications has he filed?
Two application.
His 2 applications have been rejected. He is now before this court with this instant application. One of the main ground to support his case raised by the Learned Counsel for the petitioner is that this court had relevant orders granted pre-arrest bail to some of the co-accused herein, and as such, on the ground of parity, this petition, the prayer of the petitioner, may also be allowed. Secondly, it is also submitted that the petitioner is a young person of about 20 years old and is a student of madrasa,
Yes, ma'am.
studying Maulana
Course.
He hails from a humble and respectable family, and if arrested, his future and education will be jeopardized. Thirdly, the Learned Counsel has submitted that the petitioner has no previous criminal antecedent, and as such, if in the event of his arrest he is enlarged on bail, he is willing to abide by any condition fit to be imposed by this court. Ms. Angel Leonard, Senior GA, appearing for the state respondent, has vehemently objected to the prayer made by the petitioner. Firstly, on the ground that the application is filed, the petition is filed seeking bail on the principle of parity, wherein there is no evidence to show that the case of the petitioner herein is similar to the case in which this court has granted relief to the petitioner therein. Secondly, since the offence involved offence involved inter alia section 307 IPC, which is serious offence, therefore the prayer of the petitioner may not be granted at this point of time. Thirdly, the Learned Senior GA has submitted that the last bail application filed by the petitioner was in the month of January 2024. Almost 2.5 months have expired since then, yet the petitioner has not yet been arrested. Yet the petitioner is has not been arrested, which indicates that there is no apprehension whatsoever as far as he is concerned. On these grounds, the prayer made in this petition is hereby opposed. This court has given considerable thought to the submission made. It is evident that investigation is still going on, and the IO is yet to file the charge sheet. The court has no record of police action taken. The court has no record of the status of investigation at this point of time. Be that as it may, taking into account the fact that the petitioner is a young person who is a student, and also the fact that he has agreed to bind himself with any condition fit to be imposed by this court, including the fact that he shall not abscond and that he shall cooperate with the investigation. This court, in the particular facts and circumstances of this case, is inclined to allow the prayer of the petitioner. Consequently, the prayer made is allowed. In the event of his arrest, the petitioner shall be released on bail on the following condition. Same condition as
My lord.
Lordship, I'm not aware as to whether charge sheet has been filed or not, my lord.
It should have
My
been.
lord, as per my instruction, not yet filed, my lord. As per my instruction.
Because the last bail application was January, Lordship, so 2 months and a half has
No,
already
thereafter,
passed.
the Shirazul, I have filed the bail application number 1 in the month of February. February 8, my lord has passed the grant the bail. February 8, my lord.
Even if at this point of time charge has not been filed,
Yes, my lord.
and they would have been, or they are not in custody.
Yes.
My lord, my only apprehension is what if it has been filed, like, as your Lordship pleases. Lordship.
You can take necessary steps at this point of time.
Lordship.
Yes, ma'am. Highly obliged.
Much obliged, Lordship.
Item number 3.
With regard to the accused not reporting back to the district prison, my lord, where the lordship has directed the accused.
You have not approached the trial court for.
My lord, a trial court has already passed an order issuing NBW to the bailer. So, and the matter, my lord, in one of the case, the second matter, my lord, that is NDPS 11, it's coming up on Friday, 22nd, and the other on April 1st. So, my lord, a bailer has been summoned by the court, my lord, and NBW has been issued to the accused as well as the bailer. However, my lord, in the present situation, my lord, we have not taken steps to the petitioner, the son as well as the accused, because, my lord, they are absconding. So, my lord, if lordship permits, then, my lord, we can take steps upon through the bailer, my lord.
You see, why have you come before this court when
My lord,
Matter has been
our
taken
intention
cognizance
of
by
come.
the trial court.
No, my lord, the only intention which we have come to the before this honorable court is that lordship, we have come to the authority of the prison department, my lord, since the accused has not reported back, in order to avoid any kind of orders that may come, that the authorities may be questioned, my lord. That is why this application has been. Otherwise, my lord, trial court has already taken cognizance of this matter, my lord.
Exactly. That's
My
the
lord.
situation is such.
My
that
lord, yes.
The respondent herein has failed to
Report, my lord.
before
Comply to your court order.
for the district prison authority as directed by.
My lord, yes.
In such an even the step that you have to take, which you probably have taken, is
My lord.
to approach the trial court, get an order for issuance of a warrant of arrest.
My lord, I believe
So that has been done.
this has been done.
So now, what's the next step?
The trial court has to take actions.
It is
my
to
lord,
await
yes.
the execution of the said warrant.
My lord, yes.
I think this.
I think, my lord, our only apprehension was that the officials should not be condemned by this court. That is the only reason. Now that we have already filed this application and trial court has already taken cognizance, my lord, I believe our prayer is successful, my lord. Our officers are not to be
Yes,
held
I
responsible.
think
That is
you-
our
you are-
only intention, my lord.
See, nothing is reflected as against you.
My lord, yes.
You are the prison authority. The accused. The accused was released on bail by virtue of this court's order. Directed to report by virtue of this court's order.
My lord, yes.
Failed to report. Where is your complicity there?
My lord,
You are-
I believe, my lord, this matter can be actually closed since the trial court has already passed necessary orders and they have already fixed the date for the appearance of the concerned bailer.
You withdraw it. As and when, if any situation arises, then you can oppose this court.
My lord.
So I'll treat this dismiss as withdrawn.
My lord, we will withdraw this matter. However, my lord, if we may be given the liberty, if any new...
See, what liberty is you proceed in accordance with law, and if the matter comes before this court, so be it.
My lord, I'm highly obliged, lordship.
Ms. Arpani Leonard J, appearing for the petitioner, has submitted that this petition will be allowed to be withdrawn. Petition accordingly dismissed as withdrawn.
Item number 2.
My lord, 1 and 2 are same.
Item number 3.
My lord, this matter may kindly take away at the end of the board, lordship. At the end of the board, lordship.
End of the board.
This is all connected. 3 to 9.
Item number 10.
May it please, Your
Yes,
Lordship.
please.
Lordship, these are those Nehu matters, Your Lordship. So this item number 10, Your Lordship, has been heard in part by Your Lordship. And during the course of hearing, Lordship, it had come to light because this writ petition was filed in 2015, Your Lordship. And he had availed the upgradation under MSCP, which came into effect in 2016, Your Lordship. So that was not part of the, it was not pleaded at that point of time because this is subsequent. So we had brought to the notice of this Honorable Court and wanted to amend the prayer to that extent, Your Lordship. So that petition is before Your Lordship.
May I please, Your
That
Lordship?
has not been.
Your Lordship, we have a strong objection with regards to the miscase filed by my learned senior, because there is now it is the stage of hearing, Your Lordship. So such amendment cannot be made, Your Lordship.
This was permitted by this Honorable Court long back, Your Lordship. This is not. I'm not praying at this stage. This was allowed by Your Lordship. Only the petition is before Your Lordship now. Lordship, this was allowed by Your Lordship by order dated 6/4/2022. Because what had happened, if I may apprise Your Lordship, there were those 5 matters.
Yes.
So the first one took a long time for hearing because several hearings took. So that's why this matter was not taken up at this stage. Whereas, Lordship, if I may refer to this order dated 6/4/2022, may I read, Lordship?
Yeah.
Ms. A. Paul, learned senior counsel, appearing on behalf of the petitioner at the outset, has submitted that the petitioner may be allowed to amend the writ petition, particularly the prayer portion, to include a new pleading. On consideration of the same, prayer is allowed.
It's what took you so long?
Lordship, this matter did not come up for hearing after that because that other matter was being heard.
That's beside
Lordship,
the point. You see,
Lordship.
that's beside the point. Whether it came out for hearing or not,
Lordship.
it was posted in the cause list for
Lordship,
from
Lordship,
time to
Lordship,
time.
Lordship.
Then in
Yeah,
that
in such,
case,
you see,
Lordship.
in course of such proceedings,
Lordship.
you were permitted to file the application. You could
Lordship,
have filed.
Lordship, that because because the other matter was being heard. My apologies to that extent, Your Lordship. Lordship, because this is my learned friend will also agree that this is a subsequent event which could not have been pleaded at the time of Lordship.
That you could have, you see, like I said, in course of proceeding,
Yeah.
you could have introduced those new facts, provided the other side has no objection, or if they have objection, the matter will be heard. But the fact remains that by virtue of this order, you have been allowed to amend.
Lordship. So
File-
that
file-
application is there,
but-
Lordship.
Your Lordship, this is
Exactly.
from
Now, this application
2022.
has been filed only now, after 2 years.
Yes, Your Lordship, from 2022.
This matter was not heard. That number one, which was in that list, was being heard all along.
See, Ms. Paul, we are
I admit, Your
we are not
Lordship.
talking about hearing the matter or not. I
Lordship.
said it is there. See,
Lordship, this
is
should have
there
been
on-
before the court earlier.
it is there on
I
board,
admit, Your Lordship.
all along.
Lordship, I admit, Your Lordship. My apologies for that, Lordship.
Your Lordship,
apologies,
whatever submission she wants to make, she can do it during the time of hearing, Your Lordship.
I think my learned friend is not gone through the petition which we have filed, Lordship, because this is
give her
a...
a copy.
We
Lordship,
have
it has been
just
served on
received,
them.
just received in the
You
morning.
respond to the same. You file an objection. He's just prolonging the matter.
Then, Your Lordship, in that case, the matter may come up at the end of the board because Mr. Esten, he's on leg before courtroom number 2, Your Lordship.
You have to just respond to this.
Yes,
You have your argument was very clear. I could understand you. So why would you need your senior to come and reiterate the same?
Yes, Your Lordship.
Ms. A. Paul, senior counsel appearing for the petitioner, has submitted that this court by order dated 6/4
2022, Lordship.
6/4/2022 had allowed the prayer of the petitioner to amend this petition, particularly the prayer portion. It is also directed that an appropriate application is to be filed in this regard. The learned senior counsel has further submitted that the petition is now preferred. The said petition is now filed before this court for consideration. Yes, learned counsel appearing for the respondent has strongly objected to the filing of the said petition, which is registered as Miss Case number 46, 2024. However, this court is of the this court would allow such response to be put down in writing, to which the respondent is allowed to file an objection thereto. Accordingly, let the said objection be filed and the matter to be heard in due course. This is matter after 2 weeks.
Lordship.
2 weeks.
Lordship, there's a connected matter with it. Item number 11, Lordship. Ajay Krishna Bhattacharya, this is also a similar matter. Your
Same
Lordship.
order.
Sim. But with regard to item number 12, Your Lordship.
Change tako to ka this case number mo ka 11. Yes, 12.
Item number 12, which is also listed together, Lordship, that is again a separate matter and that has not been heard. So that may be released from part heard, Your Lordship.
Not been heard.
That's not been heard.
We'll commence the hearing now.
Lordship, because these are shown as connected matters, Your Lordship.
Not necessarily.
That is how it's been shown in the list, Your Lordship.
They may be connected.
That is what has been my submission all along, Your Lordship, if Your Lordship kindly recall, that all these Nehu matters are not connected. They stand on their own individual footing. And I think that has become very clear now after the disposal of the item number 1, which was shown connected with these matters. So even these two matters, which is now before Your Lordship, these also, the facts are different. But this item number 12, where the other two matters, these are totally different matters, Your Lordship.
Okay, 12.
Lordship. Bring those to that.
We'll leave it as it is. Post this matter after 2 weeks and we'll see.
Lordship, item number 12, Lordship. My humble submission, Your Lordship, because this has not been heard at all, so it is not part heard.
So we'll
And otherwise also in view of the notification now, Lordship,
make
because
order to the So you want to take your chances elsewhere?
not that, Your Lordship, it may be here, but it is not part heard. It is my duty to point out to this Honorable Court. And they are not connected matters, which has been my stand all along.
Which was, not.
That is why they are
not-
just,
not agreed to by the respondent.
Yes, but I think it is more than evident now.
The facts has to be gone
For
into.
facts and issues are all different, Your Lordship. It's not only the facts, the issues are very different.
Learned, I have to go. Ms. April, Learned Counsel, Learned Senior Counsel, paying for the petitioner has submitted that this matter has not been heard and as such may not be kept as part heard as has been shown in the cause list. This being the case, let the matter be taken up for hearing on the next in the next date. On the next date,
Obliged, Your Lordship.
list the matter after 2 weeks.
Obliged.
Yes, you have to. Have you filed? Have you got? October 13. Miss Learned Counsel for the petition has submitted that no instructions have been received as far as substitution of the deceased petitioner is concerned, and as such, some time is prayed for. Some time is prayed for in this matter. As prayed for, list this matter after 2 weeks.
Item number 14.
May it please.
So 14, 15, 16 same.
Connected, my lord. Connected. My lord, here very limited question of law is involved. My lord, here this is a petition under section 482 for quashing of proceedings before the special court, CBI court, here in Shillong. My lord. Here what has happened, my lord, initially, my lord, a complaint was filed against some officials of NEU, my lord, against particularly Regional Center National Afforestation and Eco Development Board, NAEB Shillong.
Where is the impugn order, Mr. Gautam?
My lord, here, my lord, what has happened is that, my lord, impugn order is at 10910. Charge has been framed against me, my lord, and trial is been initiated.
Yes, sir.
The last 2 pages of my criminal petition, my lord. Charges, my lord, is in 109.
Yes, yes.
Charges have been framed under, my lord, section 420, 13(2) of the Prevention of Corruption Act, under section 468, and my lord, other sections of IPC. So, my lord, basically, what is my argument before this honorable court is?
No, but why have you come before this court under section 482?
Well, I am saying that, my lord, no case is made out against me, first of all, because CBI during the entire investigation has called me a private person. I am not a public servant. I do not come under the definition of public servant.
Under the CRPC
My lord,
or under the law of procedure,
lordship,
if charges have been framed
my lord,
and you're aggrieved by that,
my lord.
is your remedy? Is there no remedy, in the normal course available to you?
My lord, I have to come under 482 or by way of a revision. My lord, even if a revision lies also, my lord, 482 is permissible, my lord. The reason why I've come under 482 is because, my lord, I am saying the entire investigation and the filing of charge sheet and the proceedings pending over there is an abuse of the process of law. Firstly, because, my lord, I say that the entire investigation and the charge sheet was filed on the basis of a pseudonymous complaint, which according to the CBI manual, which they have to follow to the T, is not permissible. When a pseudonymous or an anonymous complaint is filed against an official, my lord, that complaint cannot be taken cognizance of. Number two, my lord, in the pseudonymous complaint, my lord, which of course they do not agree to my argument, they say that, my lord, they got some source information. But when we read the FIR, the first complaint which was filed, it is very, very clear, my lord, that whatever has happened on the basis of this pseudonymous complaint only. Now, CBI during the course of investigation has time and again called me a private person. And at the time of filing charge sheet, my lord, instead of filing charge sheet against the government official who was the coordinator of this entire institution, has filed charge sheet only against these private people. So I have been, my lord, instead of me being, my lord, called a private person and charge sheet not being filed against me, because otherwise I say there is no offence made out against me, I was working under the instructions of the coordinator who was the head of the entire institution. CBI at the time of filing charge sheet says that this particular person is not involved, all of you are involved, go and face trial. And, my lord, the only remedy I have is petition under 482. My lord, in fact, my lord, even though the petition is quite voluminous, my lord, my argument will be limited to only two aspects. My lord, this matter has been pending for quite some time, my lord, I agree. My lord, I have had a discussion with my learned senior also, my lord. We both are willing to file a written argument with some case laws, my lord, if lordship permits me, my lord. These only two aspects.
You still have to,
my lord.
You still have to present your oral argument.
My lord, the reason why I am saying this is, my lord, I have to get some authorities also, my lord. Today, my lord, of course, my lord, I have gone through the last order. I totally apologize before this court, my lord. I had a matter pending before the division bench, my lord. It was a murder appeal, my lord. I was totally engrossed in preparing that one. So these case laws are not with me. I am asking for a very short time. These only two aspects of the argument will be placed before this court, and thereafter, my lord, lordship may hear us if lordship wants to. Otherwise, lordship may pass necessary orders, my lord. Because, my lord, if lordship will see, interestingly, the contents of the FIR filed by this NGO, my lord, which after verification from the police we could not find out, my lord, there was no such NGO. The person who has filed this particular complaint, Mr. Atul Rava, does not exist. The NGO does not exist. There is a report of the police also, my lord, which we have annexed. Subsequent to that, my lord, CBI on the very same premise, citing source information, has investigated the matter, my lord, which is very well within their purview. But, my lord, instead of filing charge sheet against the main accused, my lord, who is the coordinator of this particular organization, these three people who were appointed as research officers on a contractual basis for a short period of time have been implicated and charge sheet has been filed against them. Unnecessary, my lord, they have to face trial. That is the limited case I have before this court, my lord. And I also say that, my lord, I do not come under the definition of the public servant as defined under the PC Act, my lord. Nothing else, lordship.
Sorry, we are not advancing argument, Mr. Gautam.
My lord, this is the only argument I have. My lord,
you are hit by this order.
Lordship.
You pay cost.
Well, I have already argued, my lord. This is the only argument I have. The only reason, my lord, I am saying is that I have filed a written argument because the petition is quite voluminous. Some of these things have to be pointed out and read out, which will take a considerable amount of time.
You should have let him pray for adjournment.
Well, we both, in fact, my lord, we both agreed. Both of us agree that we have both dragged this matter, unfortunately, for a very long time. In fact, my lord, I will not blame my learned senior also. Earlier, it was Mr. Jindal who was appearing in this case. Thereafter, my lord, there was a change of guard. And then, my lord, my learned senior did not have the copies of the petition. Well, I have given it to him also. Well, from my side, I have cooperated. And the only thing left now for us is to put a quietus to this matter. And we've agreed, we're both willing to file our written arguments. Otherwise, it's only limited.
Well, basically, they have taken only two grounds, my lord. We have filed our affidavit, my lord, and we have counted both the contentions of the petitioners, my lord. Firstly, he is saying, my lord, the pseudonymous complaint cannot be taken. But here we proceeded on the basis of a source information, my lord. And second contention is that, my lord, they are not public servant. Our case is that when this offence was committed, my lord, they were public servant. Of course, as a research scholar, but they're paid by the government, my lord. So they'll fall within the definition of public servant. This is basically a question of law only. He has to substantiate his case by judgment. Actually, there is nothing much on that.
But at the time of initiating the investigation, my lord, CBI has time and again referred to these three people as private persons, my lord. That is their initial investigation. But I don't know what happened at the end of the investigation.
Who else is involved in this case?
My lord, in fact, my lord, the director of the institution was involved. There is one more public servant, my lord, who has not come before this court. But these three people, my lord, they were only appointed.
But what happened to them?
Well, against the director, CBI said that you initiate departmental proceedings. I don't know whether departmental proceedings were initiated or not. So we have been singled out.
No specific charges have been framed against him?
No, my lord. He was given a clean sheet. No, he said the CBI says that no offence is made out against the main accused.
And who else is involved now? You said a
My
public
lord,
servant?
three of us, and there is one more person, my lord. I think he's a private servant, my lord. I think he's Mr.
Sivasankar Chaturvedi.
No.
Sanjeev Kumar Jha.
Sanjeev Kumar Jha, my lord. I think.
Who is he?
And one of the petitioners have also passed away, my lord. The one who's before this court. I filed an affidavit along with a death certificate also.
Who's passed away?
It's item number 15. Niyanta Purkash.
You have not made any submission in that regard.
My lord, I have already filed an affidavit before this honorable court. My learned friends wanted some instructions from the CBI because they do not believe in the affidavit filed by me.
Was any order passed in that regard?
No order was passed, my lord. He wanted to seek some instructions.
This is in this first case?
In number 15, my lord, second one. Mr. Niyanta
Excuse me. It's okay.
So this they can bring on record before the trial court, my lord. Where the trial is proceeding, this matter can be closed then.
That we can do, my lord, before the trial court. But I don't know.
And they can place this on before the trial
Second
court.
case?
Second case.
Okay. Oh yes. Charges have been framed, you said?
Charges have been framed, my lord.
So yes, they are supposed to be before the trial court.
My lord.
Some witnesses have been examined already.
Two or three have been examined. And thereafter they are not calling any further witnesses.
How many witnesses are there altogether?
Quite a, I do not exactly know the number, my lord. I think more than 50, 60 if I'm not mistaken.
So what do we do with this? As far as this number 2 is concerned, then we'll dispose of this matter then.
Number 15, my lord, yes.
But it may be disposed with the direction to them to place before the trial court that he is deceased, so
yes,
trial will be dropped against him.
So that will save your taken. Matter will be taken as heard.
Yes, well.
The lordship has heard the matter. Very limited submission, nothing more.
We're talking about item number, the second one.
My lord, 15 is disposed. 15 can be disposed today.
Criminal petition number 30.
30.
Petition number 30, my lord.
Criminal petition number 30, my lord. Item number 15.
But you're referring to 50. Who is that? 50?
Item number 15 in today's cost list.
15. I'm a bit confused.
Well,
Case number or item number?
Case number is 30.
Mr. K.C.H. Gautam, Leonard, counsel for the petitioner, has submitted that the petitioner in this case is since deceased, and the factum of his death has been brought to the attention of this court by way of affidavit. Where is the affidavit?
The affidavit dated 2nd August 2022, my lord.
Dated 2nd August
2022.
Wherein the death certificate was also enclosed. This being the case, the learned counsel would submit that this matter may be disposed of as not prosecuted. Yes, Dr. N. Musika, learned DSGI has submitted that he has no objection to the prayer made. What has, however, prayed for this court that while disposing of this instant application petition, the factum of death of the petitioner may be brought to the notice of the trial court by parties concerned. Accordingly, on consideration of such prayer made, this petition is hereby disposed as infructuous. Needless to say, as has been submitted by the learned DSGI, the learned counsel for the petitioner, or the legal heirs or legal representative of the petitioner, of the deceased petitioner, are directed to inform the trial court of this, of such fact. Petition disposed of. On prayer made by the parties, immediately. This is 2 weeks.
2 weeks.
This is matter to 2 weeks.
Duly obliged.
Item number 19.
My Lord, we have placed the summary of written arguments today with copy to the respondents.
Yes, Dr. Muziga, have you filed yours?
I've received it, my Lord. I'll file my submission for 3 days time. I'll file it.
My Lord.
How long?
Within this week, I'll file.
Mr. B. Pratap,
Matter may be reserved, my Lord. In the meantime, I'll file it.
Learned counsel appearing for the petitioner has submitted that the summary of arguments filed by the petitioners is brought on record for this court, copy of which has been also submitted to the learned DSGI. Declared to the counsel of the respondent in India. Dr. Musical learned DSGI has submitted that he may be allowed to file a response to the same in a week's time. Accordingly, this is matter to 1 week.
It may be reserved also. I'll file in the meantime.
So that will not do. File your, then let it be brought on record. Yes, sir. In case you don't do, then what will happen? Huh?
I'll do that.
1 week's time you file it.
Well,
Item number
Thank
21.
you, Mr. Pathak. All the parties are here.
Well, state is here, private is also. For respondents 4 and 5.
Okay.
And for the state, your lordship.
You are appearing for respondent.
For the state, one.
State no, one.
Respondent 1, 2.
One, 2, and 3, your lordship.
Who's appearing? You are appearing for 4 and 5.
4 and 5.
Three, 4 and 5. Interesting. Please.
But in this batch of matters, my lord, item number 3 and 4 are, though more or less identical, but 3 and 4 are more identical, my lord. And so today item number 3 and 4 are taken up, my lord. But those are more or less identical, similar facts and similar law points, my lord. So, my lord, lordship kindly takes up the WPC 469, my lord. 469 of 18.
Yes.
This is a case of dismissal from service, my lord, of the school teacher.
When were you dismissed?
469, I'm not in 469. 469 has been come by, if I'm not mistaken, by KP or Kami, one of them. I mean, this is a 468.
468 and 469 are different.
Is it connected? But the 469, the file is not with me, your lordship. I'm only endorsed into 468.
I'll refer to 468 then.
Yes, 468.
My lord, this matter pertains to Garo Dubi Higher Secondary School, my lord, in Garo Hills, which was established in 1994, my lord. This is a ad hoc grant in aid school. Now, since its inception, my lord, in the year 1994, the petitioner was appointed as assistant teacher in the school. Now, while he was teaching in the school, my lord, there were several irregularities in the school, and that was directly affecting him, my lord. The irregularities, my lord, if I may just refer to para 4 of the affidavit, my lord, of the writ petition. Para 4, my lord, that the petitioner states the respondent number 4, that is the principal of Garudubi Higher Secondary School, never pays full salary to the petitioner and other teaching staff. For all the time, the principal pays salaries after a substantial deduction from the sanctioned amount in the guise of administrative charges. The principal was irregularly disbursing the monthly salary to the teachers, and there were several instances in the past when he did not even pay the salary after repeated requests and representation made to him seeking for the monthly salary. Coming to para 5, my lord.
Yes.
The petitioner states that in the year 2014, the principal, who was also the secretary of the managing committee of the school, had withdrawn 3 months' salary for secondary section, that is salary for the month of November, December and January. He also withdrew salary for the month of December 2013 for higher secondary section. However, the salary was not disbursed to the teachers and kept all the teachers in darkness about the release and withdrawal of the said salary. Thereafter, on inquiry from the office of the respondent number 3, it was found that the respondent number 4 had withdrawn the said salary from the office of the respondent number 3, and eventually partial salary was paid to the teachers after filing representation dated 25/2/2014. Again, in the year 2016, the salary for few months, although released and withdrawn by the principal, but the same was not disbursed to the teachers, and later on partial amount was paid to the teachers after filing the representation. Para 6 also is relevant, my lord. The petitioner states the government of Meghalaya, with effect from September 2017, has enhanced the monthly salary of teacher secondary section from 10,000 to rupee 20,000 per month. The enhanced salary at the rate of 20,000 per month with effect from September to December was withdrawn by the principal. However, 2 months salary at the rate of rupees 8,000 per month was paid by the principal on 2 occasions, that is 16/12/16 and 28/12/16. The remaining next parameter, the remaining salary was kept and appropriated by the principal. The frequent financial embezzlement of the salary of teacher by the principal was brought to the notice of the district school education officer, West Garo Hills, by representation dated 7/4 and 21/47. But I may just take your lordship to those annexes, my lord. Page 17, your lordship.
Page
17, 17. This was the complaint written by petitioner and other teachers of the school, my lord, to the district school education officer, 7th April 2017. Complaint against Islam Haq Chaudhary, principal cum secretary of Garudu Higher Secondary School, for obnoxious and unauthorized disbursement of monthly salary, and humbly and most respectfully sought your immediate necessary intervention to directly disburse our salary from your end. With reference to the subject noted above, we, the undersigned assistant teachers and assistant lecturers of Garudubi Higher Secondary School, have the honor and humble submission to report you the hereunder in favor of your kind information and needful action. That, sir, it has been our painful duty to report you that in the year 2016, the respected principal cum secretary of Garudubi Higher Secondary School, in devoid of any reason thereof, has stopped our salary for 2 months out of the months September, October, November and December 2016. That, sir, on several occasions we have politely approached the principal cum secretary of Garudubi Higher Secondary School in the matter to release our salary, but unfortunately till today such approaches yet to yield any positive response. That, sir, till today we don't have salary fixation. We are getting minimum salary, and by which we are somehow arranging daily 2 square meals for our children. And if such minimum portion of salary stand irregular and sometimes not disbursed, how we will survive? That, sir, it is learned from the reliable sources that the sanction for staff salaries of Garudubi Higher Secondary School have been under withheld, so we have made up mind to knock your door for proper so and so, my lord. So this was the first complaint we wrote, my lord. After we wrote the complaint, my lord, the second complaint your lordship will see at the next page, my lord. Dated 21st April 2017. So similar content, my lord, basically. I'll not repeat, but more or less similar things, my lord. Well, after we filed the complaint, my lord, the district school education officer took some action, my lord. Page 20, your lord.
20.
Page 20, my lord.
Yes.
This is the order by the District School Education Officer. The School Managing Committee of Garudubi Higher Secondary School is hereby dissolved due to financial misappropriation of sanctioned money meant for salary of the teachers and mismanagement. The management of school will remain under the control of the undersigned with immediate effect.
Yes.
My lord, next page is another complaint, this time written to the director, my lord.
Yes.
Well, I'll just refer to a few things in this, my lord. Para 1, my lord, that through source information it has come to my knowledge that there are some anomalies going on in the Garudu Higher Secondary School with regard to appointment, mismanagement and disbursement of salary of the teaching staff of the school. That in order to get the authenticated and accurate information and to unravel the truth, I have sought an information from the District School Education Tura, requesting him to furnish some information to me, so and so, that in pursuance to my application dated 1/2/17, the District School Education Officer by letter dated 6/2/17 directed the Principal cum Secretary Garudu Higher Secondary School, West Garo Hills, to supply him the information as sought by me, as the information pertains to the school of the Principal cum Secretary of the Garudu Higher Secondary School, and accordingly some information was furnished to me. It is pertinent to mention that the information officer have not disclosed or furnished some vital information to me till date. That after proper scrutiny and on careful perusal of the information furnished to me, following grave anomalies and mismanagement were found to have committed by the Principal cum Secretary, West Garo Hills. As per the pay statement provided by the information officer, the name of the incumbent principal, Sri I.H. Chaudhary, who is also the secretary of the managing committee of the school, appears to be the staff of both secondary and higher secondary section, and also shown to have withdrawn the salary from both the section in the capacity as principal in secondary section and assistant teacher in higher secondary section. That the incumbent principal and secretary have made some appointment in the name of some fictitious person whose name were never existed in the school teacher attendance register, and as per the pay statement furnished to me by the information officer, the monthly salary of such fictitious person was shown to have withdrawn by the person named. The induction of the fictitious person in the teaching staff is a clear manifestation for misappropriation, embezzlement of the salary in the name of such non-existent person, and the same has been brought to the light from the pay statement furnished to me by the information officer.
What's the date of this letter?
16th May, my lord. 16th May 17. 16 May 2017.
Not indicated in the.
But only on the left hand side, the date 16/5 is mentioned.
That is the date of receipt.
Date of receipt, my lord. My lord, next page is the director forwarded this complaint, my lord, to the District School Education Officer, page 23.
Yes.
Second paragraph, you are requested to inspect the school immediately and to submit a detailed report to the office of the undersigned at the earliest for our further necessary action.
Yes. Yes.
My lord, by page 24, my lord, the Deputy Commissioner of West Garo Hills,
yes,
my lord, page 24.
Yes.
20th June 27. Sri P.R. Sangma, MCS Block Development Officer, Silsila, so-and-so, is hereby deputed to cause an inquiry with Inspection Committee, along with police team of Rajabal Outpost regarding Garudubi Higher Secondary School. The Inspection Committee shall comprise of the following officers: Additional Director of School Education, my lord, Joint Director of School Education, District School Education Officer, Sub-Divisional School Education Officer, and Teachers Association of Tura. The inspection committee shall conduct inquiry on 23/6/17 and meet at Rajabala Police Outpost at 9 a.m. from where they can proceed for the inquiry inspection. Now, my lord, they'll take one objection, my lord, because by previous letter, Director of School Education has directed the District School Education Officer, my lord, to conduct the inquiry. But that objection will not be valid, my lord, because the committee that was constituted, my lord, lordship, will see additional director is a party, is a member of the committee, my lord. Joint Director of School Education is a member, and a District School Education Officer is also a member of the committee, my lord.
No, but is the Deputy Commissioner the competent authority?
My lord, at this stage, my lord, because this was never challenged by anybody, my lord. The action of the Deputy Commissioner. What is more important is what the committee found, my lord. Because maybe to take advantage of this, or government can clarify, my lord, how the Deputy Commissioner constituted the committee, but that, in my humble submission, is not relevant if your lordship sees the inquiry report, my lord. Any irregularity in constitution of inquiry committee will not hold much water, because the additional director and joint director and school district school education officer, they are themselves member of the committee. Now I'll take your lordship to the inquiry report, my lord.
Yes.
Page 25, my lord.
Yes.
I'll read this, my lord. This is very important, my lord. These 2 pages.
Please.
Members of Inspection Committee for Inquiry along with police team of Rajabala Outpost reached at 9:50 at Garudu Higher Secondary School to conduct inquiry and found the following anomalies. The half-yearly examination was going on. Lordship, page 25.
Yes.
Half-yearly examination was going on. Altogether, there were 11 students appearing the examination. Out of 11 students, 6 were from class 9 and 5 were from class 8. As per schedule of the half-yearly examination 2017 at Garudu Higher Secondary School students, class 6 and class 7 was supposed to be appear in the examination, but none of them were present as per routine. Student in class 10 examination is not there, but it seems no student in class 10 since there is no routine. It is doubtful of presence of students of those classes. The principal of the school, Sri I.H. Chaudhary, Islam Haq Chaudhary, was absent at the time of inspection of the school. When he asked some of the teachers' staffs, they informed that he was absent since last few weeks, whereas no information was received by the office of the DSEO about his leave application and station leave for his long absence from the school. While the inquiry committee entered the teachers' staff room and checked teachers' attendance register, we found 6 teachers' staff name, and all were present, and 2 of them in examination duty. In the same room, Vice Principal Sri Mokbul Hussain Sheikh was present. He is a petitioner, my lord, in this case. He informed that one outsider, Mr. Abu Hanif Chaudhary, who is the younger brother of the principal, is sitting in his chair claiming as vice principal of the school. Then the inspection committee entered to the vice principal's room, where we found Mr. Hanif Chaudhary, principal's brother, is there. When additional director of school education and literacy asked him about his identity, he introduced him as vice principal of the school. Later, he shown a copy of the letter which is doubtful, and at the same time is running another school, Al Amin Madrasa Higher Secondary School, Garudubi, nearby. As per office record of DSEO, resolution approval of reinstatement of Sri Abu Hanif Chaudhary as vice principal is not available as claimed by him. His name is not appear in the paste statement of the staff, hence his identity as vice principal is not known by the department. He later started shouting to us. Magistrate on duty requested him not to shout, instead to cooperate with the committee members for the entire process of inquiry. I'm reading next page. Some of the staffs were busy for video recording from Android mobile phone. While one of the inspection committee member asked one of the Android phone video recorder about his identity, he introduced himself as Abu Bakar Chaudhry, who is the son of the principal. Working as assistant librarian of the school, committee member inquired about library and stock register of the books, but nothing is available in the records. There is no post of librarian in any government school of Meghalaya, hence committee members could not ascertain from where he is drawing salary as an assistant librarian in a government aided school. While asked about identity of another Android mobile video recorder, he introduced him as Salim Chaudhry, closely related to the principal as LD of the school. We asked him to show the acquittance register of teachers payment, student register of HS section, produce book purchase register, etc. The LD informed that these are not available and all have been taken by the principal at Shillong. He says that all the registers and records were with the principal and he took away with him to Shillong, for which the reason is not known. When we asked appointment copy and their bank account number from teachers and assistant teachers, some of them were very cooperative and submitted copies of those, which have to be compared and checked from our office record. It is found there are 2 assistant teachers in political science where there is no class 12 students, whereas government higher secondary schools where more than 200 students studying have only 1 assistant lecturer in each subject. One of the assistant lecturer informed that he is appointed as political science assistant lecturer, but principal is asking him to bring certificate of philosophy MA, so he feels insecure in service as principal collected MA in political science. Upon further inquiry, committee found that principal Sri Islam Haq Chaudhry was drawing double salary, that is first as principal from secondary and as assistant teacher for political science from higher secondary section at the rate of rupees 20,000 and rupees 24,000 respectively. Inquiry team also found that one Somiul Islam, assistant lecturer for education, is a ghost teacher. He never attended his duty and none of the staff had seen him. As per the payment statement, salary for Somiul Islam is drawing regularly, but money whom to pay nobody known. It is also found that most of the members of the school managing committee are close relatives of the principal. It is his malafide intention to include all his relatives in the committee so that he can do according to his whims and fancies. Garodubi Higher Secondary School, located within a radial distance about 1 kilometer from reputed HN Senior Higher Secondary School. Parents are sending their children to HN Higher Secondary School because of good result and qualified staff. The habitation population surrounding of Garodubi HS School is very thinly populated. Parents of the students are not happy as a result of SSLC and HSLC is nil every year. So villagers sending their children to HNHS school. Moreover, principal behavior is dictatorship style, remains busy with High Court case, RTI in the other name. Teachers are not happy with the principal as salary is not paid timely and less payment and threaten the teachers for termination. Suggestion, recommendation. In view of the above findings, the committee would like to suggest the following points for the interest of the student, teachers and general public of Garodubi and surrounding villages. Sri Islam Haq Chaudhry, Principal, Garodubi Higher Secondary School, should be degraded to Assistant Teacher of Secondary Section. Vice Principal Sri Mokbul Hussain Sheikh may be promoted as Principal of Garodubi Higher Secondary School. Salary of genuine teaching staff should be paid through the bank account from the office of the District School Education Officer as per government sanction until new school managing committee is formed. Principal Sri Islam Haq Chaudhry should be refunded his grammatical mistakes should be refunded his misappropriated amount, for he had drawn double salary and a salary drawn in the name of Sri Samuel Islam, a ghost teacher. School managing committee should be constituted as per guidelines given by the department, and general meeting will be called as per direction from the DSEO, and during the general meeting video recording will be done and general public guardian parents will be called from general meeting. So while the inquiry report is so damaging, my lord, for them, is the lordship seen. Pursuant to this decision, my lord, the next page, page 29, lordship will see.
It's 29. Yes.
To implement those, my lord, this 22nd August 2017, the Deputy Commissioner recorded, my lord, whatever the resolution was passed in the, whatever was the recommendation, my lord, in the Islam Haq Chaudhry, say same points, my lord, those 5 points. And then he says, my lord, henceforth the District School Education Tura is hereby directed to initiate action as per points indicated for smooth functioning of the city schools. So DC has not passed any order, my lord. He simply forwarded the report of the inquiry committee to District School Education Officer. And thereafter, my lord, the several points were implemented one by one. Page 30, my lord will see.
Yes.
Page 30, this is a letter from Under Secretary to the Government Education Department to Director of School Education, my lord.
Yes.
Subject: complaint against Principal cum Secretary so and so, and submission of inquiry report of Inspection Committee regarding anomalies so and so. In inviting a reference to the letter quoted above, I am directed to request you to kindly issue a so-cause notice to the Principal, Garu Higher Secondary School, and afford an opportunity to explain why action as proposed should not be taken against him. Then, my lord, by next page, the Director of School Education directed the District School Education Officer, my lord, to take appropriate action to issue so-cause notice, my lord. And thereafter, my lord, by page 32, a so-cause notice was issued by the District School Education Officer, DSEO. I'll just read few lines in page 32.
Yes.
4th September 2017, my lord, to Islam Haq Chaudhary Principal, so-cause notice.
Yes.
You are hereby asked to explain why action will not be taken against you for misappropriation of government grant which has been sanctioned and released for payment of salary for the assistant teacher and assistant lecturers of Garu Higher Secondary School. Misappropriated amount which you have drawn as double salary as assistant lecturer, as principal of school, and in the name of Sri Samyul Islam, a ghost teacher. You have drawn 20,000 plus 24,000 plus 24,000 rupees 58,000 only per month, remaining absent in the school for more than 5 months without any information to the undersigned as per record of the attendance registered issued by the undersigned. By next page, my lord.
Yes.
In terms of the recommendation of the inquiry committee, my lord, the principal was downgraded in pursuance of the order number so and so. Sri Islam Haq Chaudhary, Principal, Garu Higher Secondary, he is hereby degraded to assistant teacher, and Sri Maqbul Hussain, Sikh.
Yes.
Vice Principal is promoted to the post of Principal of Garu Higher Secondary School in place of Sri Islam Haq Chaudhary, degraded with immediate effect.
Yes.
My lord, Maqbul Hussain, my lord, kindly note, my lord, is the petitioner before lordship, who was upgraded to replace him as principal, my lord. Now, page 34, my lord, see. In terms of the inquiry report, my lord, the salary were started to be paid directly, my lord, to the bank accounts of the teachers.
Yes.
But lords will only note one point here, my lord. The first one is secondary section, my lord. There are two tables here. A second one is higher secondary section.
Okay. You are also here.
My lord, I am at serial number 2, my lord, in the first table, my lord.
Yes.
But Islam I.H. Chaudhary is there in both, my lord. But his salary was nil shown at that, for that period, because the report of the inquiry said it to downgrade and not to pay his salary, my lord. Now, page 36, my lord. So one of the recommendation of the inquiry was that new managing committee should be constituted, my lord. So the action was initiated for that by page 36, my lord.
Yes.
Now, at that time, the petitioner was the principal, my lord. So DSEO wrote to the petitioner
Yes.
A general meeting to constitute the new managing committee. With reference to the subject cited above, the undersigned is hereby direct you to convene the general public meeting to constitute the new school managing committee at the earliest for smooth functioning and so and so. Next letter, my lord, the deputy commissioner wrote to the police to depute police force, my lord, at the time of holding of the general meeting for managing committee, my lord. Page 37.
Yes.
Now what happens, my lord, in the meantime, the DSEO changes, my lord. How the game now begins, my lord. Now, earlier DSEO, my lord, lordship seen the name at page 36. He was SK Saha, he was the DSEO at that point of time, page 36, my lord.
Okay.
Now here what happens, my lord, then there was a change of DSEO, my lord. The new DSEO, the moment he comes, my lord, he issues page 38 order, my lord. It says, my lord, in pursuance of the letter number so and so dated Tura Sri Islam Haq Chaudhary, the principal of Garo Devi Higher Secondary School, who was degraded to the assistant teacher, is hereby reinstated to his original post as the principal of Garo Devi Higher Secondary School, West Garo Hills, as per letter number so and so dated 6 March 20, from Director of School Education and Literacy. The reinstatement of Sri so and so, the principal of Garo Devi Higher Secondary School, is done by the undersigned after proper examination of the official records, and found that the then District School Education Officer West Garo Hills, Tura, did not follow the official procedure such as SOCO's notice, an opportunity to place his grievance before degradation of the person concerned. The letter number so and so dated 8 September 17, the degradation of Sri Islam Haq Chaudhary from principal to assistant teacher, and Sri Maqbul Hussain SK, promoted to the post of principal Garo Devi so and so, is hereby treated as cancelled with immediate effect. So, my lord, this gentleman comes back as principal, my lord.
Okay. He is respondent. Oh.
4. Once he came to power, he started playing his own game, my lord. Then what he does, my lord?
Yes.
Page 40, lordship will see. He issues SOCO's notice to petitioner once he comes back to power, my lord.
Yes.
Lordship will notice that inquiry committee consisted of joint director, my lord,
Yes.
and additional director, which will, and DSEO was a part of that inquiry committee, my lord. So officers higher than DSE, District School Education, were there in the committee, and the committee's report was accepted and acted upon. Now, when the DSEO changes, my lord, without any concurrence from the directorate or from anyone, my lord, he starts undoing everything. And not only that, he starts victimizing the petitioner, my lord. My lord, page 40, you'll see this is SOCO's notice.
Yes.
I'll take you lordship only to para 4, 5, 6, and 7, my lord. I'll just read few lines, my lord.
Yes. Please.
Para 4, my lord.
Yes.
Why had you made some bogus and fabricated complaints by number so and so 7/4/2017 and 21/4/17, which I've pointed out right in the annexure 1, my lord, that when they are not getting salary, they wrote a complaint, my lord. Addressed to the District School Education Officer West Galway Tura, and the complaints dated 22/4/17 to Sri Asahel De Shira, politician, who is not the appropriate authority of the school, against the undersigned and the managing committee of the school, which are very much detrimental in the interest of the school. Prove the allegation framed by you in your above mentioned complaint in black and white. Explain how did you acted as principal of Garu Dubi Higher Secondary School with effect from 8/9/17 to 7/3/18 in dark, as you have not taken over the charges from the undersigned and did not inform the same to the other school of staff? Well, he's asking me how you took the charge, my lord. The committee made me principal, my lord, and that's how para 6, my lord.
Yes.
Explain why you have maintained a separate teacher's attendance register which you never bring to the school and took the signature of some irregularities and defective teachers of the school who are your supporters, including yourself, in outside without attending the school. Para 7, my lord. Why had you forcibly snatched the question paper of class 11 promotion examination supplied by so and so? So we may skip. So basically his grievance is that why you acted as principal, my lord, and he issues a so cause notice. Thereafter what happens, my lord? Page 43, my lord.
43.
Page 43, my lord. The principal placed me under suspension, my lord.
Yes.
As per decision of the school managing committee of Garu Dubi so and so by the MC meeting resolution number 1 dated 7/4/18, which is duly approved by the district school education officer Gatura by so and so, Makbul Hussain SK, assistant teacher of Garu Dubi Higher Secondary School, is hereby placed under suspension from his service with immediate effect until further order. This is for your information.
Yes.
My lord, aggrieved by my suspension, my lord, the petitioner filed a departmental appeal before the director, my lord, because there is appellate provision, my lord. Now, director passed the order, your lordship will see at the next page, my lord.
Yes.
At serial number 4 is the petitioner, my lord, Makbul Hussain Sheikh, vice principal, suspended.
Yes.
Well, on the next page, my lord, the main operative part of this order, my lord, at page 45, the third paragraph, my lord, I have also received the report.
Yes.
The read few lines, my lord.
Please read.
I have also received the report filed by District School Education Officer so and so, which clearly reported that the above two teachers, Sri Sofikul Islam and Abdul Martin Account, were terminated because of the fact that these two teachers were working for the Assam state government without informing the school managing committee, which is adverse to the interest of education of children of Garu Dubi school or to any public interest. Now, after examination and observation of the documents relating to the termination of the two teachers, question arises whether the principal has followed due process of law, which is justifiable. It may be mentioned that principal has issued so cause notice. However, I am of the opinion that ample opportunity should have been provided to the teachers before resorting to direct termination from service. It is important and necessary that before direct termination of the service, the teachers should have been placed under immediate suspension pending disciplinary proceeding and inquiry, which is the practice procedure. And if the delinquent teachers are held guilty of any allegation of charge, the teachers should have been awarded with any other punishment and followed by termination from service thereafter. This being not followed in the process of action taken against the teachers, I therefore hold the direct termination order issued by the principal is not justified from the point of law and is hereby set aside. But this is talking about the two other teachers, my lord. Now comes to our part, my lord. The district school education officer, West Garu district, is therefore directed to review the termination order issued by the principal so and so. With regard to the suspension order in respect to Sri Abdul Basit Sarkar and Sri Makbul Hussain, this talks about petitioner, my lord. Yes. The district school education officer shall initiate and issue directions to the principal and the school managing committee to expedite disciplinary proceedings as per the rules, and teachers under suspension should be given subsistence allowance during the suspension period.
Yes.
So, well, in the appeal, the director directed that expedite the disciplinary proceedings and pay the subsistence allowance, my lord. Page 48, my lord.
Yes.
But by this, my lord, the principal to victimize us, my lord, returns the salary back to the government, my lord. Lordship, kindly see the fourth paragraph, my lord. The monthly salary for the period.
Yes.
The monthly salary for the period 1/1/18 to 28/2/18 of Sri Mokbul Hussain, teacher suspended. Sri Abdul Martin account, assistant lecturer in Assamese, terminated. Sofikul Islam terminated. Abdul Basit Sarkar suspended, could not make payment as they did not come to school to receive their salary, through several requests have been made by the undersigned to receive the same. Therefore, I do hereby refund an amount of rupees so and so. Please acknowledge the receipt. So just to victimize us, my lord.
Yes.
Now, my lord, the principal issues a second SOCOS notice to us. Page 49, my lord.
Yes. Yes.
But I'll just refer to para 1, my lord. It's a numbered para. The fifth para, my lord.
Yes.
You had lodged complaints dated 7/5/18 to the Honorable Chief Minister Meghalaya, and another complaint dated so and so to the Principal Secretary to the Education Department Government of Meghalaya, Shillong, against the undersigned, wherein by para number 1 and 2 you had alleged that partial salary had been received by you for the month of November, December, January and February 16 from the undersigned. But if it is found in record that you have received full amount of your monthly salary for the above mentioned months as per your pay fixed by the managing committee of the school with due approval of the DSEO, Tura. And then he says, my lord, in last sentence that we'll skip this part, my lord. Coming to next page, my lord. The second para on the next page, my lord. Moreover, it is a matter of record that you had filed a caveat petition dated 7/12/17 before the Honorable High Court of Meghalaya, wherein you had saved before the said Honorable Court that the undersigned had degraded from the principal to the post of assistant teacher by the order of so and so, and you had promoted as principal by the order of so and so.
Yes.
Then, my lord, the last para, my lord.
Yes.
Now explain why you receive your monthly salary for the month of January and February 18 from the undersigned. Even several requests have been made to you and even intimated by the DSU. Tura White letter number so and so dated 29/5/18. Is your service or your post as assistant teacher not disposal or dismissal under managing committee of the school? Are you not subordinate to the undersigned? Why did you violate the rules and regulations of the school by not receiving your salary of the above mentioned period? Is it not your trickery to lodge again false complaint against the undersigned alleging of non-making of salary to you by concocting fact as lodged by you in earlier several times? Why did you make reply to the earlier SOCOS notice? Why did you not make reply to the earlier SOCOS notice dated 26/3/18, which was served you on 27/3/18? Why you are keeping the school's documents under your custody in an authorized way, like teachers, attendance register, answer script, attendance sheet, so and so? Despite ask you to submit the same to the undersigned, why action should not be taken against you for your such willful, irresponsive? Now you kindly see the language of the SOCOS notice also.
Yes.
Now, my lord, page 53.
Yes.
By this order of 4th September 18, my lord, pursuant to the SOCOS notice, a minor penalty of censure is imposed on me, my lord. Second para, lords will see. Hence, the penalty of censure is imposed upon Mokbul Hussain. Page 53.
Yes. Hence, a penalty of censure.
Upon Sri so and so, but in the meantime, his suspension is hereby revoked with the following terms and conditions.
Yes.
He shall have to withdraw all his false complaints lodged against the principal secretary against the managing committee of the school. Well, kindly see the conditions he imposes, my lord, after imposing the penalty. that I have to withdraw the complaint, that he shall have to tender a written apology to the principal cum secretary of school for his mistakes.
Yes.
He shall have to give an undertaking to the principal so and so that he shall sincere in his school duties so and so so and so. So, my lord, the so-called notice or disciplinary proceedings culminated with imposition of this penalty, my lord. In their wisdom, they thought of imposing a minor penalty of censure, my lord. Suddenly, thereafter, what happens, my lord? My lord, you can kindly see the date. The censure was imposed on 4th September, my lord.
Yes.
4th September 18. By the next page, my lord, just immediately thereafter, after 2 weeks, my lord, I've been dismissed from service again now.
Yes. September
21st September. Just after 2 weeks, after once a penalty has been imposed, my lord, those proceedings are over. There is no occasion for them to pass a second order, my lord.
So this dismissal was based on which, on the
My lord, they're referring to again to the same so-called notice, my lord.
additional charges, anything? Okay.
Now, my lord, I'll take your lordship to the operative part of this order, my lord, page 57.
Yes.
The last para, my lord. On the premises above,
Yes.
it is held the good and sufficient reasons that the continuance of Sri Makbul Hussain so and so in service in prima facie detrimental to the interest of education and discipline of the school, and thereby in pursuance of the MC meeting resolution number 1 dated 30/10/2016. Well, these dates are very important and interesting also, my lord. He refers to MC resolution number 1 dated 30/10/2016, my lord.
Yes.
And lordships have seen when was the first so-called notice issued to me, my lord? First so-called notice. Page 40. My lord, the so-called notice itself was issued to me on 26 March 18, my lord.
Yes.
And what the order says, my lord, MC resolution of 30/10/2016, my lord. And then it says, my lord, with due approval of the DSEO Tura, white memo number so and so dated 4/11/16, my lord. My lord, my so-called notice is of 2018, and my termination order is of 21 September 18, my lord. How can there be prior approval to anything, my lord, when even the so-called notice has not been issued to me, my lord? And by referring to this approval, there's a purported approval, my lord, and as instructed by the district school education officer so and so by letter dated 4th November 2016.
Yes.
The service of Sri Makbul Hussain SK, assistant teacher, is hereby dismissed. My lord, kindly see the 3 dates was what he is referring to, my lord. My lord, why this is important, my lord? Because your lordships have dealt with several matters, my lord, where prior approval from the government is necessary for dismissal of teacher's service, my lord. So to cover that, my lord, because they don't have a prior approval, my lord,
Okay.
they are trying to refer to something of 2016, my lord, which has no bearing in this case. Those 2016 letters or managing committee resolution are altogether different issues, my lord, which have nothing to do with the present proceedings, my lord. Now, my lord, page 58, that is the 4/11/2016, my lord, what they've referred to, my lord.
Yes.
I annexed that. What is that, my lord? Your lordship kindly see, my lord.
Yes.
My lord, this was from BG Momin, who is the SDSU now, my lord, because he was earlier also DSU, my lord.
Okay.
4 November 16 to the principal cum secretary Garo Dubi, pay held up of Garo Dubi Higher Secondary School as resolved by the managing committee of Garo Higher Secondary School wide meeting resolution number 1 dated 30/10/16.
He is also referring to the same
thing, my lord. Which is duly approved by the undersigned, wide number so and so dated 4/11/16. You are directed to held up the monthly salary of the following teachers with effect from November 16 until further decision of the managing committee of the school. My name is there, my lord. So, my lord, what was the resolution of 2016 was only to withhold my salary for some reason, my lord. Well, can this be construed as a prior approval of the government, my lord, for my termination, my lord? And the managing committee resolution which they are referring, my lord, that also is I have annexed, my lord. Next page, your lords will see.
But here it says further you may suspend or terminate the above mentioned teacher.
Yes, my lord, but pursuant to this, no action was taken, my lord. I continued as a vice principal. In fact, I was made principal also by the committee. I was downgraded to vice principal. But allow me to serve, to take away my service in this manner, my lord, by the principal, and who is guilty of gross negligence in the school, my lord. Your lordship seen the inquiry report. Drawing double salary, appointing his brother, his nephew, his all kind of relatives, my lord, ghost teachers, and he is taking action against me, my lord. And even the managing committee resolution kindly see, my lord. Resolution number 1, my lord, the next page.
Date? Page 50?
Page 59.
59. Yes.
Peruse the complaint of parents, guardians of a student against some teachers of the school, namely Mokbul Hussain, Abdul Matin Akon, Sopikul, so and so, for gross negligence of their school duties. On the basis of the complaint, explanation was served to them by principal cum secretary to the school to the said concerned teachers, but they did not receive the same, and instead of receiving, they misbehaved with the principal for issuing such explanation. After a long discussion, the house is opined to withhold them monthly salary for the month of November 16 onwards until further decision of the MC. As per the offence committed by them is serious in nature and most disobedient to the school authorities, I also resolved that their services may be suspended or terminated, which may deem fit and proper if they involved and found in further such activities in future, which are detrimental and against the interest of the school. Hence, principal of the school is empowered to issue necessary orders in this matter to the concerned teacher. My lord, you have seen, my lord, this is provisional, my lord. If they repeat in future, something they could have suspended me, but my lord, this decision of managing committee is in altogether different perspective, my lord, for a different cause of action. Now my dismissal is for a different cause of action, my lord. So this managing committee resolution cannot be resorted to, or at that point of time, if there was any approval for termination of our service, my lord, that cannot be, because my proceedings in this case starts in October, my lord. So any approval of 2016 or they dig out some approval of 2010 or 2005, my lord, that cannot be resorted to, my lord. Well, my simple case is that we are subjected to victimization, and we were subjected to victimization because the committee, the inquiry committee of the government, my lord, made me principal for a certain period of time, and because we filed complaint for non-payment of salary, and it has already been established more or less, my lord, that the principal was misappropriating the school money. And the legal aspect, my lord, since there is no approval of the government, my lord, my termination is without authority of law, my lord. This has to be set aside, my lord. On that, I can play. And my lord, this fact is admitted by the
We have
government. My lord.
crossed the
The time, my lord.
schedule.
Quite a bit.
Everyone is too engrossed in your eloquence.
Thank you. I'm
So what do we do?
Only 1 minute I'll take, my lord. Only one document I'll just, then I'll conclude my argument. They can reply today or whenever they want.
Yes.
But in the connected matter, the government has filed an affidavit, my lord. The other matter, where government in para 17 of the affidavit admits that no prior sanction of the government was obtained before terminating or dismissing the petitioner, my lord. So government clearly admits.
That was the condition precedent.
That is a condition precedent. Your lordship has passed several orders on that line. Section 9 of the Meghalaya Education Act. The prior approval, and there's a series of case law on that, my lord.
Yes.
So once government admits, my lord, the private respondent cannot override government and say something different, my lord. The government is the person, is the authority to admit, and they are admitting that there is no prior approval.
You're referring to?
I'm referring to the affidavit filed by the government, my lord.
Dated?
Must be dated to 29/7/19, my lord. 29 July 19, or maybe 1 or 2 days, because we received on 29/7, my lord.
19.
19, my lord.
Para
17, my lord. In item number 4, they filed this affidavit, my lord. That is in WPC 469, my lord. I was arguing 468, my lord. In 469, the government is filed affidavit.
Okay.
The criminal case. My lord, one important aspect, my lord, we filed an additional affidavit in this case, my lord, that the respondent number 4, my lord, case is going on against him in Lokayukta, my lord, and he was even arrested by police for misappropriation of the funds, my lord.
Of the school?
The same respondent number 4, my lord, for this school, my lord. Because of misappropriation, case is going on in Lokayukta, and he was even arrested by police and put behind the bars, my lord. And he served jail for quite long period of time, my lord.
So we'll continue on next date then.
My
lord. Heard Dr. N. Learned Senior Counsel, appearing for the petitioner. The hearing will continue on next date fix. This is matter after 2 weeks. We show this matter after 2 weeks, no?
Bye.